Greetings, ladies and gentlemen. I am Tinodai Shesawi, a student at the University of Zimbabwe, where we are under the Faculty of Business Management, Science and Economics, doing public relations and marketing. So we are going to delve into a discussion whereby we will be discussing about the regulations of commercial advertising. There's a scholar called Worker. He suggests that it is generally accepted that the content of advertising should be regulated. This ensures that rivals play by the same rules. Although only a small proportion of the millions of advertisements published each year are false, misleading, unfair, offensive, or socially irresponsible, or are perceived as such by the marketplace. Simply another scholar points out that every industry has its charlatans, and advertising is no exception. These offenders hamper the functioning of the market system, harm or insult consumers, and reduce the overall credibility of advertising. It is therefore generally argued that it is both in the public interest and in the interest of the marketing communications industry that advertising should be regulated to secure the confidence of consumers and government alike, and achieve the necessary credibility and reputation to inspire public confidence in advertising. So I now leave the platform to the one who is going to define terms.
Good day to you all. My name is Melissa and I'm going to be defining terms. First term I'm going to define is commercial advertising. Dennis 2015, Raymond and other scholars agreed to define advertising as the direction of one's attention to an idea, product and service by announcing an oral or written message to the common public. It is an advertisement which has its primary purpose the promotion of the sale of goods and services by commercial businesses or enterprises to the public generally, or any significant part therefore. I've got some few examples of commercial advertising, which is television, commercial advertising, radios and internet. And then I'm going to go on to define the following term, which is a regulation. And it goes like this. As suggested by Mosa 2015, regulation is a form of government intervention in economic activities and interference with the working of the free market system.
Good day everyone, my name is Melissa Makondo. There are several acts or statutes that govern and monitor the regulation of commercial advertising in Zimbabwe, and these include Advertising Regulation Act, Consumer Protection Act, Broadcasting Services Act, and Competition Act.
My name is Sarah and I'll be presenting to you about the Broadcasting Act. As you can see on the screen,
the Broadcasting Service Act articulates that on advertisements relating to medicine, a broadcaster must not broadcast an advertisement relating to a medicine unless the text of the proposed advertisement has been approved. It goes on to say, no advertising agent shall own, control, or hold securities in any license. In addition, the standards and practices to be observed in advertising through a broadcasting service including notation of certain methods and practices of advertising, the length of advertisement, and times at which certain advertisements may not be aired or aired with restrictions. The Act also portrays that commercial broadcasting licenses shall specify what broadcasting time shall be allocated to advertising.
Good day, ladies and gentlemen. My name is Daphne Chanakira. I will be telling you about the Consumer Act, which is showing on the screen.
Consumer Protection Act, Chapter 14. In relation to advertising, the Consumer Protection Act reflects that where in addition to advertising or displaying a price in relation to any goods or services, a supplier has advertised or displayed a placard or a similar device announcing that prices are, will be, or have been reduced by a monetary or a percentage value, or in relationship to any particular goods or services that advertised or displayed price for the purposes of subsection 5 shall be regarded as being the price advertised or displayed in relation to the goods or services, minus the announced monetary or percentage reduction as stated on the section 36 of the Consumer Protection Act.
Hello guys, my name is Leroy Chakunda Mshonga and I will be taking you through advertising standards code.
Standards Code. The purpose of the Advertising Standards Code is to ensure that every advertisement is a responsible advertisement. All advertising must be legal, decent, honest, truthful, and respect the principles of fair competition so that the public can have confidence in advertising. The principles and rules set out in this code are the standards expected in all advertising. Other advertising standard codes may also be applicable, and many sectors have their own specific advertising requirements. These must also be taken into account. I will now take you through the application of the code. This code applies to all advertisements placed in any media. Ultimately, the responsibility to be aware of and comply with all aspects of advertising regulation is shared between all the parties to an advertisement, including the advertiser, agencies, and media organizations. The code does not apply to content not controlled by the advertiser or to product labels or packaging. However, when a label or packaging appears in an advertisement, it forms part of the advertisement, and therefore invisible aspects are covered by the code. So, the Advertising Standard Code has some principles, and the first principle being social responsibility. So, I will take you through this principle of social responsibility. There are some rules which are to be followed for the advertisement to be socially responsible. The first rule being privacy. Advertisements may only portray or refer to personal information that is publicly available. Other personal information may only be collected and used with the consent of the individual concerned. Rule number 2 is consent. Advertisers must have permission from the consumer before engaging in personalized direct advertising communications. Rule number 3 is decency and offensiveness. Advertisements must not contain anything that is indecent or exploitative or degrading or likely to cause harm or serious or widespread offense or give rise to hostility, contempt, abuse, or ridicule. Rule number 4 is exploitation of children and young people. Advertisements must not portray or represent anyone who is or appears to be under 18 years old in any way that is exploitative or degrading or inappropriate for their age. The fifth rule is safety. Advertisements must not, unless justifiable on education or social grounds, encourage or condone dangerous, illegal, or unsafe practices, or portray situations which encourage or condone a disregard for safety. The sixth rule is violence and antisocial behavior. Advertisements must not, unless justifiable on educational or social grounds, contain anything that condones or is likely to show violent or antisocial behavior or damage property. Rule number 7, fear and distress. Advertisements must not cause fear or distress without justification. Rule number 8 is health and well-being. Advertisements must not undermine the health and well-being of individuals.
From the group, they've presented on the codes, the ads, and you now know what commercial advertising is. I'll take you through the cases that have been witnessed in the court of law.
One of the cases include Lafayette of Promotions CC versus South African Breweries International and Freedom of Expression Institute, South Africa Constitutional Court. This occurred on the 8th of March 2005. The applicant is Lafayette of Promotions CC, a close corporation that occupies itself with the appropriation of brands which inhere in well-known trademarks. The respondent is South African Breweries International, BV, Sebmark International, now known as the Seb Miller Finance BV, a company registered in Rotterdam in the Netherlands. The respondent is a holder and owner of the registered trademarks in issue. The respondent approached the High Court as an applicant, Keynes Food Limited versus Nitrate Marketing Private Limited. Alleging trademark infringement, the applicant wrote an application to the High Court in terms of Section 9A of the Trademarks Act, Chapter 26, against the respondent. What was sought was an interdict against the use of the offending mark and ancillary relief. The applicant and the respondent are companies registered in Zimbabwe and involved in the business of producing and marketing food products. In particular, they are both in an endeavor of packaging and retailing fruit jam. Nitrate Company used the name Royal Sun on the jam packaging, which is directly synonymous to that of Sun's fruit jam, hence it was sued.
As we have noticed, advertising really needs to be regulated. For more information, please click on the links below. Thank you for listening.